Welcome back to this fourth and final segment of land law easements. We have explored some of the ways that an easement may be acquired, and we'll of course continue in looking at the other ways that you can acquire an easement. Now please bear in mind that, as we have already seen in a previous segment, there are certain ways to acquire an easement by grant, and only of course 3 ways in acquiring an easement by reservation, and I want you to ensure that you are very clear on these. Now, in respect of a further implied grant, there is the implied grant under Section 62 of the Law of Property Act 1925. Now, this is a legal easement, and it of course can only be by way of grant, because it certainly cannot be by reservation. Now, this is an interesting area, and as I suggested in the last segment, this is the topic, or one of the topics to consider in the context of a law exam in terms of easement, because more often than not, the examiner will test you with a Wheeldon and Burroughs question, and where Wheeldon and Burroughs meets Section 62, and it is the type of question that you will need to be able to answer and to draw the distinctions. Certainly, we will draw those distinctions here. Now then, how do you acquire a Section 62 easement? Well, Section 62 of the Law of Property Act lists the benefits that pass in a conveyance of land without being explicitly included. So what Section 62 allows is that any right or any privilege, meaning permission, or any advantage, these can be converted into an easement, making them a proprietary right if the following conditions are met. Now, Section 62 says that if the section is not expressly excluded, and that the right being claimed is capable of meeting the easement requirements set out in Ralenborough Park, as we mentioned in an earlier segment, and the dominant and the servient tenements are owned by one person, but there is separate occupation of the dominant and servient tenements, and the owner of the servient tenement uses a deed to sell or transfer the dominant tenement to the occupier, or the occupier of the servient tenement uses a deed to grant or renew a lease of the dominant tenement to the occupier, or the owner of the servient tenement uses a written agreement to grant or renew a lease of the dominant tenement for 3 years or less to the occupier. Then once these are met, then you're looking at a Section 62 easement. Now, I know that's a fair bit to have taken in, so let's try and see how we can make this a little bit clearer. When you contrast Section 62 against Wheeldon and Burroughs, I want you to first take on board that with Wheeldon and Burroughs, you can use a deed or you can use an agreement to sell the land. But under Section 62, you simply can only use a deed, which is why Section 62 starts off by saying conveyance. For you, you must take on board what the law in recent times have said. And there is a case that law students tend to completely overlook, and it's the case of Platt and Crouch. I would urge you to have a look at Platt and Crouch, because this is a case where we see the courts saying that there is very little between Wheeldon and Burroughs' acquisition of an easement as well as the acquisition via the rule under Section 62. The point, of course, is that under Section 62, you can only use a conveyance in order to be able to acquire it that way, but under Wheeldon and Burroughs, as I said, it can be either. Now, in Platt and Crouch, the court said that the historical distinction, and certainly when I learned it, this was the way we did the distinction, was to say, if there is sole legal ownership, sole occupation, and the dominant tenement is sold off, you're looking at a Whelan and Burroughs. But if you're looking at sole ownership, but diversity of occupation, that usually flags up that you're looking at a Section 62 situation. So for your purposes, these are the differences that I want you to be aware of when we look at Whelan and Burroughs as against Section 62. The first is that for Section 62 to operate, the land is owned by one person, but there is separate occupation of the dominant and the servient tenements. That's Section 62. Whereas under Whelan and Burroughs, the land is owned and occupied by the same person, and the benefited part of the land is sold off, i.e. the dominant part, and that is sold off. And of course, that would mean that you are looking at a quasi-easement then being converted into an easement under the Whelan and Burroughs principle. The second is that the right under Section 62 do not have to be continuous and apparent and reasonably necessary for the enjoyment of the land. That's the requirement under Whelan and Burroughs. In fact, under Section 62, it can be simply a privilege. It could be an advantage. So to give you for example, when you look at, say, a case like Goldberg, Edwards and Goldberg, you may want to consider what was set out in there. Because if, for example, you allow me to cross your land once, so how Section 62 manifests itself on an exam, for example, is where A owns Blackacre and Whiteacre. He rents Whiteacre to B, and then he ends up selling Whiteacre to B. Whenever you see that type of scenario, it is a red flag that you're possibly looking at a Section 62. So normally, where the owner of the dominant tenement allows someone to occupy it before doing a transfer. If that is the case, you're tending to look at a Section 62. So even if you allow the person to cross the land once, and he's never done it since then, it can mature into an easement under Section 62. Whereas with Whelan and Burroughs, it must be continuous and apparent. Now for Section 62 to operate, thirdly, the land enjoying the privilege must be sold by deed. In Whelan and Burroughs, it does not have to be sold by deed. It can be sold either by deed or a written contract which meets the provisions under Section 2 of the Law of Property Miscellaneous Provisions Act. And as such, it would mean that you would be able equally to get it under Whelan and Burroughs. The last way, of course, is a prescriptive easement, acquiring an easement by prescription. Now, in order to acquire an easement by prescription, the whole discussion of the history of the basis of this type of easement is certainly outside the scope of this video. Suffice it to say that if we look at this in a nutshell, the basis of a claim in prescription is that you have used the right for a sufficiently long period of time. And the legal time limit that we see here is 20 years. So whether you're looking under the common law, whether you're looking under lost modern grant, or whether you're looking under the Prescription Act, under the doctrine, if long user as of right is proved, the court will presume that the user began lawfully. And user is a term of art. So they will presume that the user began lawfully, that is, as a result of the grant. Now there are three methods of obtaining a prescriptive easement: prescription at common law, by lost modern grant, and under the Prescription Act 1832. But what they all have in common is they all rely on proof of continuous user as of right. And user as of right says that the use must have been done without force, without secrecy, and without permission for the last 20 years. Now, there are a couple of interesting things to take on board in terms of prescription, and one of them is this. Certainly, when you're looking at a prescriptive easement, if there is any sort of permission, please look at what the examiner tells you that the permission allows for. Because if it is an oral permission, then it is possible to still acquire prescriptive easement, but the time may be doubled. So instead of 20 years, you're looking at 40. However, if there is written permission, you can never acquire a prescriptive easement. And everything that I've said here to you in relation to prescription, or indeed in everything I've said to you in relation to easements, can equally apply to a profita prende. The difference with a profita prende, of course, is that you don't necessarily need a dominant tenement. And as such, it makes it slightly different in that, or rather, you don't necessarily need to have the dominant servient framework that you would need in an easement. Simply, all you would need, for example, is if I have my lamb grazing on your land, then there's no necessity for there to be a dominant tenement. Lastly, of course, how do you protect an easement? Well, the protection of an easement you must consider on the basis of registered or unregistered land. The vast majority of land law questions in relation to easement are in respect of registered land. And as such, I will focus on that somewhat. But that said, of course, in unregistered land, it's pretty simple, it's pretty straightforward, and I will, of course, address that. If you have a legal easement, and I would urge you to go back and look at what I have mentioned, if you have a legal easement in registered land, then if it is an express legal easement, then you need to register it substantively according to Section 27 of the LRA 2002. But if it is an implied legal easement like necessity, will and boroughs, and so on, then it will fall under Schedule 3, Paragraph 3 of the LRA 2002 and will operate as an interest which overrides a registered disposition. So I don't need to register it and it will bind. Land law questions in relation to easements are made in this area. If it is an equitable easement, so for example a Whelan and Boroughs equitable easement, or in fact an express equitable easement, it must be registered under Section 34 or 43 of the LRA as a restriction or a notice in order to bind a party. And that, of course, is how you would protect it, as any such dealing generally will have to be considered thus. Now, what about unregistered land? Well, in unregistered land, the fact is, or the two rules really, are that legal rights bind the world, but equitable rights bind everyone except a bona fide purchaser for value without notice. However, please bear in mind that an easement is one of those that is required to be registered. Think of Midland Bank and Green, but it is the type of interest, equitable interest, that must be registered in order to bind. Hopefully, this has given you some clarification, not least in addressing easement questions, and certainly I look forward in the next segment, or indeed in the next lecture that we have.